I'm an active rower. I've just currently finished my commerce law degree with honours at the ANU. At the ANU, I was also a research associate working with Professor Thomas Faunce, where I focused into legal issues in sports. Currently I'm a corporate tax consultant, but next year we'll be undertaking a PhD focusing on sports law to continue the research I've already undertaken, which I will discuss some of with you tonight. So this evening I will explore with you whether or not the WADA Code adequately provides for the course of natural justice for athletes involved in team sports. This presentation operates under the assumption that the WADA Code offers sufficient provisions of natural justice for those competing on an individual basis. The Essendon football saga was the first incident where a team was brought before the Court of Arbitration of Sport, CAS, in Switzerland by WADA. Subsequent to this, last year, several Russian teams who were due to compete at the 2016 Rio Olympics were brought under public scrutiny through the McLaren report by WADA due to clouds over the doping history of individual athletes. In this instance, the responsibility of sanctioning athletes fell from respective sporting bodies, with many Russian competitors excluded from the Rio Olympics. Now, through my involvement in rowing, I'm familiar with the case of the Russian rowers, whereby 6 out of the 28 athletes that were due to compete, only 6 were deemed eligible, but sadly only 5 were actually able to compete in the end, which therefore meant that one of the clean athletes, because of the doping of the other, 22 athletes, was forced to miss out. So do we think this is an example of natural justice prevailing? So as touched on previously by other presenters, natural justice is essentially the right to a fair and unbiased hearing. Athletes are professionals in the same manner as medical and legal professionals are, being highly trained and skilled in their chosen field. However, unlike APRA and the bar, the Essendon case provides evidence that the tribunal process regarding performance-enhancing drugs denies that same level of natural justice afforded in other professional associations. So WADA is obviously the body responsible for ensuring that the use of performance-enhancing drugs in sport remains strictly regulated, and Australia is a signatory to that code. We have ASADA, the Australian Sporting Anti-Doping Authority. So it was ASADA which brought the Essendon Football Club, which I'm sure most of you, unless you've been living under a rock, are well aware, to the Afl Tribunal over doping allegations back in the 2012 season. So at the Afl Tribunal, by the means of the links in the chain approach, ASADA had to prove the following 3 links which are on the board. So the first one being that TB4 was procured from Chinese sources. Then secondly, the second link, it was compounded by Nima Alavi and then provided to Stephen Dank in his capacity as an Essendon employee. Finally, the final link was whether or not it was injected into the 34 Essendon footballers. So the case failed at the first link, and therefore a link had been broken in the chain, and therefore it was held that there was no contravention at the AFL Tribunal. And therefore the third was never considered. So that poses the question, how did, using the same evidence, 2 different tribunals reach starkly different determinations using the same evidence? So approach used by WADA at CAS with a much lesser evidentiary burden used predominantly testimonial and circumstantial evidentiary strands in the cable. So this included evidence such as that players were secretive with their dealings with doctors, doping control officers and ASADA investigators. Furthermore, under these dealings, there was no record kept. The fact that there was no record kept was, in the CAS's view, suggestive of a desire to shroud the regime in a veil of secrecy. Furthermore, what happened with the Cronulla Sharks up in Sydney and the fact that they accepted sanctions due to a doping regime which was also implemented by an Essendon employee, further added and thickened these strands in the cable. So the strands in the cable approach involved the use of predominantly testimonial and evidentiary strands to convince the CAS to be comfortably satisfied that all players had violated the Australian Football Anti-Doping Code. So the majority of Essendon football players were young adults, trusting that the club would do everything in the players' best interests. So how were they to know that they were required to take daily steps to ensure if they were ever found themselves before the CAS, that they must be able to disprove WADA's circumstantial evidence and strands in the cable approach? If natural justice were to be sufficiently provided for, it should not be upon the athlete to prove their innocence. Instead, the prosecution, in this case WADA, must be able to prove their guilt. Through this circumstantial evidence, CAS was comfortably satisfied that the players were concealing evidence which in their eyes was an admission of guilt. In considering the evidence from a fresh perspective, as Kim said previously, de novo judgment, was at the expense of natural justice. This is of concern for future Australian doping allegations and probably in other nations as well, as it enables ASADA to use WADA's ability to bring a case to the CAS and make use of this lower evidentiary threshold. If we take, for instance, if this was a dispute in any other professional realm, for instance, a ruling by an Australian tribunal in a health professional sphere, such a dispute could be taken to the Supreme Court or, on principle, on further appeal to the High Court. In such instances, both parties would be subject to the regular evidentiary burden and thus afforded a sufficient level of natural justice. So, is the WADA, the World Anti-Doping Code, appropriate for team sports? So WADA obviously has a strict stance on doping in sports to ensure that an environment that fosters doping does not exist. Requiring athletes to be self-responsible for ensuring a prohibited substance-free environment is, in my view, the correct course of action, because in order for the WADA code to be taken seriously, the consequences must directly affect the athletes. The same goes for their coaches, sporting administrators, and medical support staff. Consequences must directly affect the athlete for the code to be taken seriously. Whilst the low evidentiary burden of proof appears unjust and unfair, such a standard forces athletes to be responsible for what substances go into their bodies. However, is the World Anti-Doping Code adequate for those partaking in team sports? For example, take tennis, an individual sport predominantly, where players and coaches ultimately have complete control over their training regime and therefore arguably have a greater ability to control what supplements are being consumed. If we contrast this to a team sport, such as a football team in the AFL, if a player were to question what supplements he was taking when participating in a team sport, that has the potential to be inferred as questioning the judgment of coaches or may cause disruption to team unity. It may have been the case for many junior players to have either participated in the supplements program or risk being perceived as questioning the judgment of their peers or coaches and selectors, and therefore forfeiting their place in that team. Furthermore, if we look at rowing, is it fair that a member of a crew is found guilty of doping, that the entire crew is sanctioned, even though there may be clean athletes in that boat? So furthermore, the motivation to dope can differ between team and individual sports. So it's likely, highly likely, that Lance Armstrong, his motivation to dope would primarily have been to enhance his personal chances of victory and then the subsequent financial gains that would stem as a result. If we contrast this to a football player, team players are under the direction and influence of club officials, administrators, coaches, fellow teammates, all people of whom they place great trust. A primary reason for the popularity of sport is the culture it fosters and the fulfilment of belonging to a team. Such a culture is built on trust for peers, coaches, administrators, medical and support staff who are all employed with a common goal, their club's success. This creates an environment where younger, naive athletes may potentially reluctantly or unknowingly engage in doping in order to remain part of the team, and therefore fail to ask the appropriate questions as a result of ignorance because they have placed ultimate trust in those in their team. So the Essendon Saga obviously highlights flaws within the anti-doping regulatory system that ultimately acts to deny athletes of natural justice concerning those involved in team sanctions. Through the tactical wider appeal of the Afl Tribunal's decision to the CAS, a lower evidentiary burden was employed to conclude that the 34 past and present Essendon players had committed a doping violation. In this instance, WADA only needed to prove that CAS that the facts made it likely, and not certainly only likely, they had engaged in a supplement programs contrary to the code. The lessons of the Essendon supplements case should be reflected in changes for team-based infractions in the AFL code and the SADA and WADA procedures that give greater emphasis to natural justice protections. This could potentially be in the form of ensuring cases are processed in a timelier manner to reduce the detrimental effect of a ban on a team, or so that an alternative avenue can be pursued so that clean athletes, like rowing, are not sanctioned as well. Furthermore, could be looked to sanction the team as opposed to the athlete to cause a less detrimental effect to someone's reputation and instead sanction the club where it can be shown that the club was largely at fault. As it stands, the current WADA World Anti-Doping Code does not adequately provide for individuals involved in team-based doping sanctions. The code should be altered to adequately provide for natural justice protections, which ultimately will not be an easy task.